Hello? Yeah. The September 12th Compliance and Amendments Committee of the Sunshine Ordinance Task Force meeting is now starting at 4:05 p.m. And
On the call of the roll, Member Highland.
Here.
Highland present. Member Moss.
Here.
Moss present. Chair Kanata.
Here.
Kanata present. We have a quorum. I'd just like to let you know that I have received an email today from Mr. Mooney for file number 3, file number 15139, requesting continuance. We can get to that as soon as we do the minutes. It might be easier.
Yep. Okay.
And there are no other agenda changes that I know of at this time.
Okay.
Would you like me to call item number 2?
The next item, please.
Item number 2, approval of the August 16, 2016 Compliance Amendments Committee meeting minutes.
Do we have any edits or updates for the minutes? Committee members? Yeah. Do we have a motion to approve?
So moved.
Second.
Okay.
Is there any
Public comment on the approval of the minutes from the last meeting? Seeing no public comment?
on the motion to adopt the minutes? Member Highland?
Aye.
Highland, aye. Member Moss?
Aye.
Moss, aye. Chair Kanata?
Aye.
Kanata, aye. The motion passes. Item number 3, file number 15139, hearing on the status of the order of determination complaint filed by Sean Mooney against the Assessor Recorder's Office for violating Administrative Code Section 67.21B. On August 16th, 2016, the Compliance Amendments Committee continued the matter and requested that the Assessor Recorder provide verifications as to whether or not the tax roll account numbers were provided to the complainant. I did receive an email from the complainant today requesting a reschedule. I am not completely sure for the reason. However, I believe that the Assessor Recorder has provided verification that he has provided that information. I believe the Assessor Recorder representative is in the room today.
Okay. Okay, is that Mr. McCaffrey?
It is.
Could you please come up and
Sure.
comment on the email that was sent and what the status is?
Absolutely. So, good evening, members of the Sunshine Ordinance Task Force. This is Eddie McCaffrey reporting from the Assessor Recorder's Office. And I would direct you to a notice that we submitted on August 17th, 2016. It was provided to you all the day after the last hearing. And in that letter, it indicated that we had previously provided to Mr. Mooney the account numbers, as we call them, or as Mr. Mooney has referred to them in the past as tax roll account numbers. We provided that information for previous years, 2014, 2015, upon his request. And in that same email, I included attachments that include the same documentation as well as the information that he has on record. That is what we were requested to do, we were asked to do at the last hearing, and we have confirmed that information via this notification. The email that Mr. Mooney sent today, only I think a couple hours ago, is actually related to a completely new request, not related to this one. Mr. Mooney's request connected to the complaints that we've been talking about for some time, file number 15139, is related to years 2014 and 2015. Mr. Mooney's email today is related to 2016. There's been a variety of email communication that the Sunshine Ordinance Task Force has been CC'd on between Mr. Mooney and I, specifically to keep it organized and to differentiate 2014 and 15 requests and 2016's request. And so at our last hearing, I do remember Mr. Mooney bringing up his issues with the 2016 data, and I do also remember that the members, attendance of that meeting, guided Mr. Mooney to put that aside because it wasn't related to the issue that is being addressed in file number 15139, which was 2014-2015. That being said, I'd be happy to talk about our correspondence since, but I think happy to answer any questions.
Okay, thank you.
Through the chair. Mr. Clerk, do we have copies of either of these emails that are referenced?
I have it on my phone. I was not able to print out a copy as I was in the previous meeting.
Can you pop it on the screen? Is that possible? that's hard. You can just pass it around. Okay, thanks. Just give us a moment. Okay, you guys take a read of that.
Should I just read this out loud?
You can.
I can do that.
Okay. Yeah, I mean,
I can do that.
because we do need to show the audience this, I think, or
Yeah, just get it on the
let
record. And perhaps the email before it, too, with Mr. McCaffrey's response. Do we have that in our...
Yes, it is listed below. There is an email from Mr. McCaffrey to Mr. Mooney at 2:07 p.m. today. It's addressed to Mr. Mooney. In hopes of keeping our communication clear and open, I wanted to provide you an update regarding your second request for PEI data related to Torney parcel permits. At 1:44 p.m. today, you emailed me a different thread and confirmed that the outline provided you in my email from Wednesday, September 7, 2016 is accurate. Thank you for doing so. We will begin working on this request. I cannot confirm when this information will be made available, but I will update you periodically of our status. And then just skipping a little bit below, request number 1, PI data for 2016 supplemental tax roll, sequence 2, request 2 PI data for permits. We've not begun working on this request yet. Reasoning being, I would like you to confirm that you're asking for tax ID numbers, also known as count numbers, and the 502P forms or the equivalent information as required for the list of parcels below in my September 7th email.
I think that's enough, Mr. Clerk.
And then going to the original request for the recalendering. Victor, based on Eddie McCaffrey's email today at 2:07 p.m., please recalendar this item. Based on Eddie's email, it appears that there is no purpose of the meeting today. Eddie's email acknowledges I have not received information requested, and he is only now starting to acquire the information. Therefore, it appears he is now 100% clear on the information requested. Therefore, please continue this matter to the next meeting.
Through the chair. So that's the second piece, which I think we're on the same page as with Mr. McCaffrey. In other words, that this is regarding data for 2016, in which case what I'd like to suggest to Mr. Mooney is that he open a separate, give Mr. McCaffrey a reasonable amount of time. If he doesn't get the data he wants, he can open a further complaint. However, what I'd like to hear is, was our last instruction from our last meeting followed? In other words, the PI data, I'd like to see that email in writing and some acknowledgement from Mr. Mooney showing that he received 14 and 15. If we can see that, then I'd like to make a motion to close those cases.
There is an email from Mr. McCaffrey retransmitting the data to Mr. Mooney. I'm not sure how he responded to that. All those emails are in the file, but I am not sure if he ever acknowledged that that was responsive to his request.
Okay.
But the instructions of the task force was to provide the tax roll account numbers. I believe that is where we left it at the last meeting.
And did we receive a copy of that from Mr. McCaffrey?
Yes, we did. He provided it to us in an email. I believe a copy of that is in our packet today.
Okay. Mr. Chair, I think my inclination on this is probably to make a motion to consider this closed. I think Mr. Mooney has recourse to repeal that if he needs to. Is that right, Mr. Clerk?
He can refile a complaint for 2016, but in terms of the 2015, we are, once we state that the assessor recorder has complied with our order, that would conclude the matter, as we've already found a violation on this matter.
Yeah, and just to be clear, he's never filed a complaint on 2016?
No, he has not.
Okay.
That'd be new matter.
Okay, so was a motion made?
Would you like to confirm with the assessor recorder to be?
Yeah, Mr. McCaffrey. So based on everything, you've been up to all our meetings, that last piece that we asked for, do you believe that you've satisfied that?
Absolutely. Yes, I have. Absolutely. In hard copy that was handed off to the clerk's office as well as in soft copy, we feel we have given Mr. Mooney the account tax ID numbers that he requested.
Okay. And did you get any response from Mr. Mooney saying, thank you, we're all set for 14, 15, how about 16? Anything to that effect?
No confirmation of 2014-15 that I am aware of. That being said, we've been talking about 2016 for the last month.
That's encouraging, at least. Okay. So it sounds like maybe he's moved on and he's looking for 16 information. I think that's probably good enough for me. So I'll make a motion to, I guess, table this item.
Table it or
The motion would be to find that that the respondent has complied with the order of determination and to conclude the matter.
okay.
Same thing.
Sorry, does he need to restate that motion?
As amended.
All right, then I second.
Any public comment on the motion? Seeing no public comment, let's have a vote.
On the motion to find that the respondent has complied with the order of determination and conclude the matter, Member Highland?
Aye.
Highland, aye. Member Moss?
Aye.
Moss, aye. Chair Kanata?
Aye.
Kanata, aye. The motion passes.
And through the chair, thank you, Mr. McCaffrey, and please try and work with Mr. Moody on 2016 data so we don't get to see your selection of neckties for the next year.
No problem at all. If I may just add one more thing, I think our correspondence, I've been working with Mr. Mooney's on email. I've been doing my best to make sure the task force is included on that communication so that it's a running thread that we can make sure that you have a very clear lineage of the response time, what we're asking for, and that sort of thing. So if we do come back, if I do come back in 2016 and maybe 17, we can have a much more thorough conversation and outline it a lot cleaner.
Great.
So
Thank
thanks
you.
everyone for their guidance.
Thank you.
Thank you.
Okay.
Next item, please.
Next item on the agenda is item number 4, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Is there any public comment? Seeing none, next item, please.
Next on the agenda, item number 5, file number 16059, complaint filed by Sabrina Butler against Sheriff Vicky Hennessy and the Sheriff's Department for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner.
Okay, is the complainant here?
Is the complainant here for item number 5? Is Ms. Butler in the room at this time or a representative? Does not appear to be one. Is the respondent here for this item? Or Representative
Freya Horn from the Sheriff's Department.
Ms. Horton is
Okay.
here from the Sheriff's Department.
Please step up. You have 5 minutes.
Through the chair, since the next two items, I think, are the respondent is the same, is that correct?
No,
Mr.
they are
Clerk?
not.
They're not, okay. Never mind.
However, usually when the respondent does not appear without providing prior
I
notice,
mean,
the
complaint.
complainant does not. Our standard practice is to table the matter and to so inform the complainant. They do have the option of requesting that it be reopened with an explanation of why they did not appear at a notice meeting.
Okay.
However, we should not begin a hearing on this matter without
Both parties.
both parties present in this case, otherwise it could cause issues.
Okay, do we need a motion to table it?
I don't know if there's any. Has Ms. Horn, have you heard anything from the?
Could we, through the chair, could we at least maybe push it back one item? Is that a possibility? You can give her an extra 15 minutes to show, and then perhaps.
Okay, is that okay with the respondent?
Is that all right if I come back?
Absolutely. Thank you very
If
much.
you'd like to leave me your number, I can give you a call.
554-4334.
Thank you.
Thank you.
We will temporarily table this matter and move on to the next item.
Okay,
Item number 6, file number 16062, complaint filed by Magic Altman against the Police Commission for allegedly violating Administrative Code, Section 67.9, and California Government Code 954.3 by failing to make supporting documents available 72 hours prior to the Police Commission's June 22nd, 2016 meeting regarding the use of force policy.
Okay, is the complainant here?
Yes, I am.
Come on up, you have 5 minutes.
Can we make a motion for jurisdiction prior to this?
Okay, motion for jurisdiction,
So moved.
seconded.
Oh, sorry.
Is there any public comment regarding
Jurisdiction.
of the task force on this matter?
Okay.
There is no comment. Can we take that motion without objection?
Yes. Okay, now you have 5 minutes, please.
Thank you. My name is Magic Altman. First of all, thank you for the time and attention you are giving today to the concerns of the public on this matter. Having attended government meetings for over 25 years, I've always appreciated the respect for the public's rights to all pertinent information 72 hours preceding the actual meeting time. Without this window of time, it is virtually impossible to be well informed about the issues at hand. The use of force policies are a grave matter that can make the difference between life and death. During the months of review of said policy by the Police Commission, the public was always kept appraised of the current drafts of the working documents until June 22nd, 2016. At every previous meeting, the public, community stockholders, such as the ACLU, as well as members of the Police Officers Association, made extensive comments that included crucial critiques and suggestions. This policy had not been updated for over 20 years, and with the recent spate of tragic killings by officers, the public outcry for reform was heard in the streets, at the Board of Supervisors, and in the meetings of the Police Commission. Then, as the June 22nd meeting date drew near, special closed-door meetings were held between the POA, Police Commission members, and other community stockholders, but not the public at large. The new version of the use of force policy was not available to the public or even some members of the Commission until the meeting on June 22nd. I've included in your packet the second and third versions of this document. The second version was the last document that the public saw before the meeting. It is, as you have seen, 68 pages long. It included the arguments that the POA had put forward to oppose many of the suggestions made by the Commission, the public, and community stockholders. The private meeting was most likely a well-intentioned attempt to resolve issues with the POA that has been used to pushing its agenda pretty successfully over the years. Regardless of intentions, we the people do not want our representatives to assume they know better than the people and therefore can skip over the implicit right of a 72-hour review. This disregard also denies the public's unique right to bring many diverse voices into the conversation. Even if the commissioners thought they had the public's interests at heart, we are not children who need to be taken care of. It is our right to be an educated and thoughtful people. It was impossible to be able to speak from a fully informed position at that meeting. There was an urgency to get it done that day, and in fact, the vote was unanimous. Ironically, the intended goal of finding compromise with the POA while running roughshod over the rights of the public has since fallen apart. Today's request of this body is simple. We, the people, ask you to inform the Commission that they violated the 72-hour provision, and so they are on notice not to repeat this disregard for the right of the public to be fully informed of the business of the government. I noted on this agenda for the task force only 67.9 of the Sunshine Task Force Ordinance was cited. It is important that the task force also include Section 67.7 before making an informed decision on this matter. I refer to the following. A, at least 72 hours before a regular meeting, a policy body shall post an agenda containing a meaningful description of each item of business to be transacted or discussed at the meeting. B, a description is meaningful if it is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item that he or she may have reason to attend the meeting or seek more information on that item. The description should be brief, concise, written in plain language, easily understood. It should refer to any explanatory documents that have been provided to the policy body in connection with an agenda item, such as correspondence or reports. These documents, if they're more than 1 page in length, must be made available for public inspection. As you well know, the purpose of this task force is to help ensure that the government fulfill its duty to serve the public, reaching its decisions in full view of the public. And I quote, "Commissions, boards, councils, and other agencies of the city and county exist to conduct the people's business. This ordinance assures that deliberations are conducted before the people and that the city operations are open to the people's review. Respectfully submitted, Magic Altman.
Thank you.
Thank you.
Is there anyone else here to offer support for the complainant? You have 3 minutes, sir.
Thank you. My name is David Carlos Salaverry. I'm a member of a group called San Franciscans for Police Accountability. We have been following the Police Commission hearings and specifically the use of force issues since they began basically last December. The stakeholders group that actually worked with the POA in order to come up with a new use of force policy itself was completely in the dark about what document would actually be at the meeting on June 22nd. We met with Alan Schlosser of the ACLU. He was not at all clear what document would be brought forward to the commission hearing because at the time there were 3 different use of force drafts. There was a 2, there was a 2A, and then subsequently what they actually put on the table, draft 3. Nobody saw it until literally 45 minutes before the meeting. In fact, it was such a chaotic process that they didn't even have enough copies of the draft for the many, many people that were there. It was actually in this room here. It was packed to the gills. So not only did they have enough copies of the draft supplied by the commission, actually somebody had taken it upon themselves to print out an extra draft, but because they had printed it from a different system, none of the pages lined up. And so it was incredibly confusing during the commission hearing exactly what everybody was referring to in terms of the real details of the use of force policy. So the fact that this was all done at the last minute, there was a deal that had been brokered between the head of the POA, Halloran, and the commission president, Susie Loftus, that the 80% that was agreed upon as far as the use of force would be finalized and voted on, and everybody's signature would be on that document, and the 20% that was not agreed upon would be something that they negotiated later. Instead of that happening, Halloran came to the meeting and basically blew up the agreement that had been announced ahead of time, and therefore it was just an incredibly chaotic process. And the fact that none of these documents were made available to the public ahead of time. When we met about 45 minutes before the meeting, not only was it ACLU attorney Schlosser there, one of the commissioners was there as well. He didn't know what the final draft was going to be. So this is a situation where you guys really need to weigh in with the commission and tell them that this chaotic process that you guys allowed to happen just cannot absolutely happen again. So we're hoping that you will decide in favor of notifying the commission of those issues. Thank you.
Thank you. The respondent here, please. You have 5 minutes.
Good afternoon, members of the Sunshine Ordinance Task Force. My name is Rachel Kilshaw. I'm a sergeant with the San Francisco Police Department and the Commission Secretary. And in reference to this complaint number 16062, based on the plain reading of the Administrative Code 67.9 and Government Code Section 549.543, there is no explicit requirement to provide supporting documentation of an agenda item 72 hours prior to the meeting. The only expressed requirement is to make the agenda available 72 hours prior to the meeting, which the Commission did, and to provide materials to members of the public prior to the start of the meeting, which the Commission did. And in the packets that we have provided to you, you can see there are emails to show or the agenda. We can show that we put that out 72 hours. And there's emails in that packet to show that we did provide 50 colored copies to the to the members of the public, along with a copy in the binder for public review containing the supporting document of all items on the agenda. The draft version of the use of force policy, titled Version 3, was provided to the Commission office in the late afternoon of June 22nd. The document was not available 72 hours prior to the meeting. And again, in the packet, you can see the emails going back and forth between members of the stakeholder group. And you will also see that none of the Commission members were included in those meetings or in those emails. These were meetings between various members of the stakeholder group. The draft version of the use of force policy presented to the Commission on June 22nd, as represented by Commissioner Loftus, did not have substantive changes from version 2 or 2A, which had been posted on the Commission's website for over a week, and the concepts in version 2A were all in version 3, which is that June 22nd version. At the Commission meeting, President Loftus went into recess prior to the discussion of the use of force draft policy to allow commissioners and members of the public to review the document. And again, proof of that is in the packet with the meeting minutes. The meeting that Ms. Altman referred to as a private meeting with the subcommittee use of force commission, those were two separate meetings that she's referring to. There was a meeting on June 17th, which was the Commission Use of Force Subcommittee meeting. That was noticed, and I actually did not print that out to provide to you, but I do have a copy with that. That was noticed, and members of the public actually did show up to that meeting. At that meeting on June 17th, Commissioner Loftus directed the members of the stakeholder group to come together over the next few days to come up with a draft version. None of the commissioners were at that meeting, at those several meetings. Let's see. As a reminder, the vote on June 22nd was to move the policy forward in the meet and confer negotiations between the City and County of San Francisco and the Police Officers Association. After the negotiations, an updated version of the use of force policy will come back to the Commission for a vote on adoption. The public will have an opportunity to review that document and give public comment prior to the Commission voting on whether or not to approve that version that results from the meet and confer process. The version that went before the Commission on June 22nd was not up for adoption. It was up for moving forward to the meet and confer.
Okay. Thank you.
Thanks.
Members of the task force. Oh, any speakers in support of the respondent? Seeing none, thank you. Okay, members of the task force. Ms. Altman, I have a question for you. A couple of ones. The respondent said that there were 2 meetings that were noticed, and she mentioned the 6/17. Was that meeting noticed?
I was not aware of it. I can't say it.
You don't know if it was?
I don't know
Okay.
about it.
Would you pull the microphone?
Oh, sorry. Yes, of course. You're welcome.
Okay. And then in your opinion, the differences between version 2, 2A, and 3, were they substantive?
Yes, including such items as the carroted hold, shooting at a moving vehicle, and Penal Code 835A. We were calling for a higher bar than that penal code, and the POA wanted to keep it as the highest bar. And that was a direct quote from Petra de Jesus, one of the commissioners there.
And were those 3 items in 2A or handled differently in 3, or what was the differences?
It's my understanding that they were different, and that, as she said, it still is in process, but we need to have time to review every step of the way, and we were not given that time. I'm not aware of the other meeting that was mentioned by her, and she said none of the commissioners were there, but was there someone representing the commissioners? Because I don't know what that meeting was about. Also, there was language about the sanctity of life that was changed between those versions, and it was difficult to hear because the police force, the chief, and many high-ranking officers kept using the term sanctity of life, and then as soon as this version came up, version 3, that was completely changed. So I feel those were significant. They are still up for debate. That's how significant they are, and the Department of Human Resources is actually working on negotiating with the POA, and she mentioned 9 issues that are still up, 3 of which I have mentioned here.
Okay, thank you.
You're welcome.
Member Highlands.
Through the chair, Ms. Altman, a few more questions for you. If you could reapproach. What action, if any, took place at that meeting, that June 22nd meeting, based on this version 3?
They approved of moving forward with version 3.
Which means?
That they, basically it was a unanimous vote, and they felt they'd kind of sewed it up.
Okay.
So, it's the negotiations fell apart shortly after that. So it's actually still in process.
Okay. So I guess my question is this approval to move on with this particular version was brought up again in future agendas, and the public had an opportunity to comment on them in the future? I'm sorry, I'm asking her.
Not as far as I know, and I think that what's important here is every step of the way, whether it's a final decision or one step to move forward, the public needs to have 72 hours to review materials, or they cannot make, a legitimate decision. And they mentioned, Sergeant Kilshaw mentioned the 15-minute recess for people to review. That's hardly enough to review these long documents with any real comprehension of what they're about.
Great. Thank you very much.
You're welcome.
Ms. Kilshaw, if you could approach. Just looking at versions 3 here in our packet, there's certainly a lot of strike through. There's certainly a lot of changes here. And acknowledging that the body makes the call on what is substantive and what's not, would you reasonably argue that this is not substantive, these
I would. I think so for example, the term that Ms. Altman was talking about, the term sanctity of life, for example, had been used throughout. It was a term that some members of the public, some members of the stakeholder group, and including some commissioners were not comfortable with. They felt it had a religious connotation, and so then they came out with the safeguarding of human life. The concept is the same. When she talks about whether the carotid restraint, shooting at vehicles, those items, they were actually in version 3, and then the commission as a body, and had been in various versions 1, 2, 2A. There were separate versions being proposed by various stakeholders, and so. The version 3 had all of those items in it, but the commission went forward to strike those moving forward with the meet and confer. So it's all of these sort of philosophies and policies were in various versions 1, 2, 2A, depending on which stakeholder group proposed them. And so again, as Ms. Altman said, it was a progression of versions. I would say that most importantly, the commission did not have the items 72 hours ahead of time. I know that Ms. Altman.
Yeah, if you can go a little more detail about that.
Right.
So give us a timeline of when. I see the emails saying that you received it, and we're going to make 25 copies.
OCC is going to make 25 copies, right?
Give us a timeline on that, if you would.
Okay. So just can I go back to the meeting that maybe Ms. Altman was confused about? There was public notice of just for the timeline, there was public notice of a June 17th Police Commission Use of Force Subcommittee. That was put out. And there were members of the public who did attend that meeting.
Excuse me, and this meeting was specific to changes to this document?
It was a discussion, yes, about where moving forward.
Okay, I'm explain the term moving forward to me in this context.
Commissioner Loftus had asked that this item be placed on the agenda for June 22nd. There were several items, as referred to by Ms. Altman and Mr. David Olive, that there were some items that were agreed on between all of the commission, between all of the stakeholders, but then there were some that they could not move forward with these items. And so...
And just to interrupt, so on June 17th, it was version 2A that was being discussed?
It was version 2 and 2A.
Okay.
Right. So, because there were...
And was this a regular police commission meeting?
It was a sub-commission meeting. It
Okay.
was at the Public Safety Building. We noticed it. We put it on our commission. We did all the requirements that we had to. And members of the public did show up.
Okay.
And so there was a recognition that, at that time, which... similar to body-worn cameras, there was several versions moving forward that they would like to see one version move forward. And so we had this meeting on June 17th. These two of the three commissioners did show up. And there was discussion. As a result of that meeting on the 17th, Commissioner Loftus asked the members of the subcommittee who came to please meet outside of the commission, that no commissioners came to that meeting, and there were 2 or 3 additional meetings. No representative of the commission showed up. I was not there. This was outside commission business. And so they were working on this. I think the 17th might have been a Thursday or Friday. They worked on it, I think, Friday, Monday night, and Tuesday. Commissioner Loftus did
Let me just stop you right
Yeah.
there. So the subcommission of the police commission had how many members? 3 members?
3,
Okay.
and met one time.
It met one time. That was
On
the
June 17th.
Okay. And then Commissioner Loftus was present, the 4th member, if you like, at that meeting, or she dropped in.
She was a member of the subcommittee.
She was one of those 3.
Yes.
Okay.
Actually, there were 3 members, 2 attended.
So herself and one
Commissioner De Jesus.
other. Okay. So there was a quorum.
There was a quorum.
Okay.
During that meeting, there was discussion about versions 2, 2A, moving forward, these areas of where there was not consensus. And she asked members of the subcommittee to please meet outside of the subcommittee commission, outside the commission's jurisdiction, to see what they could come up with. They met...
So and who is they? Who are those people that you're talking to?
I believe it was the OCC, the Bar Association.
So she asked members of the public that were at that meeting.
Yes, who were representative stakeholders.
Okay, to come up with,
A version to move forward on June 22nd.
to present
Yes.
on June 22nd.
Yes. And at that time, I believe they met that Friday. If I don't have the dates correct, but they definitely met at least 2 times, if not 3. And no member of the commission attended those meetings, and no member of the commission staff attended those meetings. As a result of those meetings, they were working in person and then via email, which I've included. The emails that the commission started to receive were on June 22nd, I want to say around 12 noon. They said, we're working on this. And they were going back and forth, getting comments from each of those stakeholders, the POA, the OCC, and the Bar Association. And I want to say around 3:48, 3:50, something like that. It was, here's the final version.
Right.
I wrote back to the OCC, can you please bring copies? The Bar Association
Got it.
says,
Okay.
hey, yeah.
Just let me ask one more question, with the chair's permission. I realize those times were fairly charged, and there was a lot of attention from trying to get this document out. People were burning the midnight oil, so to speak. I'd like to actually go back and hear the subcommission's, video or audio. Was it on video? I imagine
No.
It wasn't, just audio. Did Commissioner Loftus tell these groups, please get it back to us so we can, was any mention made of the 72 hours
No,
requirement?
no.
Okay.
It was, please get it back to us for the June 22nd meeting.
And I'm guessing, members, that those other 2 groups don't fall under our jurisdiction A or B, the focus of this particular complaint. So, okay.
Is there a copy of the agenda in the package? I haven't seen it. I see the minutes of the meeting.
either, but I just went to the Police Commission website.
Okay, so my question about the agenda is, does the agenda mention a version of this document that's to be discussed? It doesn't.
It does not.
It just says that
I
the use
can-
of. Oh, go ahead.
Should I read it?
Please.
All right, to the chair. Discussion and action to approve Department General Order 5.01, quote, use of force, unquote, draft policy that for the department to use in meeting and conferring with the San Francisco Police Officers Association and Department of Human Resources, parentheses, action. That's the relevant one. There was an item right before it just about discussing what the meet and confer process was, and that seems to have been a whole separate item from discussing the actual text. Is that correct?
Yes.
So, I went through the packet and I did see all the emails going back and forth on the 22nd. With all of this last minute work, and when I look at the document, there's 32 pages of version 3 with a lot of crossouts. And I know it's the body's charge to determine what's substantive. But with all this last minute work and with a document that large to look at for 40 minutes, 50 minutes, what was the rush in having this voted on at this particular meeting?
I can only speak to what I've heard the commissioners talk about and what the community wanted. Commissioner Loftus set the time frame. She set the date for the 22nd, that it would move forward for a vote on what version would move forward. The committee was eager at each of the meetings. If you look previous, we've had this item on. There was anger in the community about an outdated 20-year-old policy. They felt that the department wasn't moving quickly enough. There were comments about people stalling it, the different, the POA. And to your comment about various strikeouts, I think those strikeouts are included in the various versions. They are sort of copied from version 2A. So version
Through the
2A.
chair, that's important. Is 2A in our package?
Yes, I believe it is.
Mr.
I believe
Clerk, can
2
you-
and 2A are in your packet.
Because, and again, this goes to a reasonable person's or a person of reasonable intelligence read. If I saw version 3 with all the strikeouts, I would assume that all those changes would have been since 2A. Not some of them, not half of them. I think the sheer volume of changes alone persuades me there was a violation here, and that's probably where I'm leaning on this. I appreciate that the heat was on. You guys trying to get this document out, and there was public outcry and demand for this product. But I think history will probably record that there was a violation of sunshine here. This is something that will be taken up probably by the whole body, but that's kind of where I'm going on this right now.
I'm not sure. Mr. Young, can you tell if version 2A and 2 are in there?
I don't think so.
I'm just looking. They have them all linked on their
Yeah.
website. That seems to be an easier way to access them than
Right.
our packet.
No, but if you're at the meeting and you got this,
But
True.
but as Ms. Altman mentioned, they've gotten copies all along. And so I would say if you're willing to put this over, I could bring copies of 2, 2A, 1, all of them, because
But
I think...
not to interrupt, Sergeant Kilshaw,
Thank
but
you.
these are these are advocates that have been following this closely, and they're struggling to keep up. Again, the law speaks to a person of reasonable intelligence and reasonably informed.
Does
So
the
I
law
think-
state you have to have the materials posted 72 hours if they're unavailable? They were unavailable.
That's something we can still talk about, and that's
Right.
something certainly.
And I would think, I would just say this, that any determination that you make, not just for us, would apply to the whole city, because I think there are many commissions that get items at the very last minute, and how do we...
And many of those commissions appear before us.
Right, and so how do we conduct business if, for example, we have something on the agenda and it only gets brought to us?
Well, every year, every department head is trained on sunshine law. And one of the most basic things is noticing agendas and items. We could easily find a violation of Commissioner Loftus for not asking these people to get this information to you in a timely fashion. If that's not in the minutes, if that's not mentioned, that might be an oversight. So, I mean, there's probably something here that, will rise to a violation, in my opinion.
Okay, and so again, just a technical question, and you maybe not answer it now or take it under advisement, is there an express requirement I know there's an express requirement to post the agenda 72 hours. Is there an expressed requirement to post the items associated with the agenda 72 hours ahead of time?
Hold on. I think that's referenced in our package and exact wordings I'm looking for.
I have not. I've looked at I've looked at 67.7 and 67.9, and I don't see where it specifically says that every document that's going to be at the meeting has to be posted. But it does say that agendas of meetings and other documents on file with the clerk of the policy body, when intended for distribution to all or majority of all of the members in connection with the matter, shall be made available to the public. And
we did.
At the meeting.
Correct.
Where, so this goes to, I think this goes to some of the issues we've been discussing in other meetings about substantive changes and the responsibility to have the public be able to digest the changes and comment on them.
And through the chair, to continue reading 69.9A, to the extent possible, such documents shall also be made available to the public body's internet site. The fact that you were discussing printing out color copies 2 hours before suggests you had a version that could have been posted at that point.
That's what I wanted to ask as well, is whether, because I see it's on the website now.
Right.
At what point was that posted?
The next day.
The next day. So after
we got it at 4. We have to get here and then set up. So we left at 4. There's 2 of us who work in the office. We got it. We made copies, and we left. There was not time to post it. We brought 50. Well, we brought 25. The OCC brought 25, and we had a copy in the binder made available prior to the start of the meeting, which is what what it says.
Did anybody ask you for a copy of the document prior to the meeting, prior to you putting them out or making them available?
No.
I have a question for Ms. Altman. At the meeting, did members of the public make comment on the changes?
I just have to make it clear, because of a yearly event with my family, I was not actually at this meeting. David was, so he can speak to that.
Okay, good. I'm assuming there was a lot of public comment because they made 50 copies of this. What occurred with the public comment based on the changes?
Well, the public comment was lopsidedly against moving this thing forward on such a rush basis. All of the justice groups that I'm a member of Justice for Mario, Justice for Amilcar, et cetera, as well as members of San Franciscans for Police Accountability, we got up and we made public comments to Susie Loftus and the entire commission, begging them to please hold this over for 1 week. That didn't seem like a huge ask. This is a critical document in terms of the police department. The use of force is critical. I mean, it's a life and death issue. So holding it over for 1 week seemed to be a very small ask of the commission. It is true, as the sergeant has said, that there's been a lot of demand for the thing finally being changed. It's the last version was, I think, in 92 or something like that. But there was no demand from the public at the meeting to rush this through on this day now. And all the demand was in the opposite direction, to please wait so that we'd have a chance to look at it.
Okay, thank you.
Okay.
And sorry, I'm not even sure who this is. Sorry, could you go back, please? I'm sorry, I don't recall your name. Could you say it again for me?
Sergeant Kilshaw.
Sergeant Kilshaw. Could you just explain to me what a draft policy for use in meeting and conferring means? It seems like this is not the final policy, that there will be more opportunities to oppose such a policy. This is just a draft to begin making another draft. Is that right?
I wouldn't say it's a draft to make another draft. So under the Miles-Mills-Brown Act, the bargaining union, and I'm just really rough. I'm not with DHR. I'm not with DHR. So that's that item prior to that you talked about. The Director of Human Resources came and explained the whole process. And so under the Miles-Mills-Brown Act, the negotiating union is allowed to go to meet and confer that for items that would affect wages and benefits, health and safety, training, discipline. And so there was discussion at that meeting that while the 80% that there was agreement on, there was about 20% where the POA, the Police Officers Association, felt that they were entitled to meet and confer and were not willing to sign off on the version that the commission put forward. And so And just to give you another step, so version 3 came forward with some items still in contention. Some items in version 3 were struck at that commission meeting, meaning the carotid restraint. It was taken out. Shooting at a vehicle, they were identified as being still in contention. The commission went with not shooting at a vehicle. So that's the version that went forward to the meet and confer. That started almost immediately after that June 22nd meeting and continues to go. I think their last meeting was earlier this week.
So then there's more negotiation that
Correct.
happens, and then there will be another version of the policy based on that. And then what happens to that policy?
Then that policy comes before the commission. That policy will be the result of the meet and confer, and there will be time for public comment on that, and then comes the vote whether to adopt that version. If they adopt it, that's what would move forward and become policy in the department. If they don't, then it's sort of back to the drawing board.
Okay, thank you.
I have a question upon that. The meet and confer was only about the 20% of disagreement?
I'm not privy to the meet and confer. That's what the public statement was. What's actually being discussed, I don't know, because I'm not privy to that.
Okay. And if it was the 80% that was agreed upon at the June 22nd meeting, when the entire document goes up again,
For adoption? Mm-hmm.
right? Is there opportunity to to change the entire document?
Yes.
Okay.
Yes.
Thank you. Anybody else?
And just one last question. It looks like you had a regularly scheduled slot the next week on the 29th that was canceled.
No, we're dark on normally the 4th and 5th weekend of or Wednesdays of the month. And that they did refer to the fact that we were in this room. That was the 4th, I think the 22nd was the 4th week of the month. That was not a regularly scheduled meeting, but again, because of the commission's eagerness to move forward, the public's eagerness to get a policy started in the process, we called City Hall and asked for a meeting here. And we were given this room.
Okay, thank you. Maybe we should hear, through the chair, maybe hear their rebuttals and then see where we are.
Yeah.
Yeah?
Okay. All right, Ms. Altman, 3-minute.
I think Ms.
believe,
Koshar goes first.
Oh, the respondent goes first. I'm sorry.
Koshar, you're allowed 3 minutes.
3-minute
to provide a
rebuttal, or add anything else you'd like to add. Or...
Yeah, I mean, I would just like to say, and we had help constructing our response to this, that again, the plain reading of the text does not have an explicit requirement for having the 72-hour, the documents posted 72-hour. We did provide them prior to the start of the meeting, did provide a recess, and I do believe it was a 30-minute recess. I'd have to go back and look. And I would just say that while I understand the importance of having the documents available to the public in a timely manner, I don't. I think a ruling on this would not just affect the police commission. It would affect the entire city. Many of the documents we get, we just don't get in a timely fashion to post on, but we do have them available for people. And you know, I think if you were to look at, and I think your colleague Mr. Mass. If you, like you were saying, if you go online and look at versions 1, 2, 2A, 3, many of the strikeouts are sort of duplicates of various versions from before. And many of the concepts that were in there are just reorganized, retooled. Some are stricken, some are not. There were 2 pretty divided camps on many of the items. Ms. Altman referred to 9 that were given at the last commission meeting by Department of Human Resources, and many of those are either in or out of both. They're in both and stricken, or out of both and not stricken. So there were no new concepts raised at in any of the versions.
Okay, thank you. Ms. Altman.
Thank you. So, you know, I did read the 72-hour, which does describe what is sufficiently clear. Shall I reiterate that, or is everybody on the same page with me? Because it says that it shall refer to any explanatory documents that have been provided to the policy body in connection with the agenda item, such as correspondence reports, and they should be adjacent. If they're longer than 1 page, which it certainly was, they should be, again, that's all under the 72-hour notice. Also, Sergeant Kilshaw keeps mentioning the urgency of the public. The public has not expressed urgency in getting this done if we don't have time to be sufficiently informed so that we can speak and make sure that our input is recognized. And when HRD had Callahan came to the meeting, she said 9 items. She mentioned 2. She was pushed by one of the commissioners to say the rest of them. She only said 4 more. When I directly asked her for the full 9, she said she'd tell it to the commission, and I said the public wants to know, and she remain silent. So it feels like there's a perpetuation of trying to keep the public out of the process. And as I've stated before, use of force is a grave life and death matter. And we do want to get this policy done, but we want it done with the full input and critique of the public as well informed. I do not believe this happened, and I'd like to move forward with the commission to make this happen so that everybody feels that their voices were heard, and what we come out with will not create more division in the community, which would be tragic. Thank you.
Thank you. Members.
I have some ideas, but I'll go ahead and defer.
I mean, I'm interested in hearing Member Highland's ideas. I'm a little uncomfortable about this on several levels. On one, that I do wonder what the impact will be meeting-wise, like citywide, in terms of a decision that we make here. At the same time, I don't like seeing an agenda item that you can just substitute anything in, 5 minutes before a meeting. But I mean, at the same time, I mean, I don't like that, and there are things that I don't like that are still legal, and I think I need to differentiate as we're going along between what I find perhaps irresponsible and what might actually be a violation.
Right.
But I'm interested to hear people who have,
Yeah.
Member Highland's take on this.
Member Highland.
Sure. Well, first of all, just to reinforce the process here. So basically, we're going to make a recommendation. We're not going to rule on anything, and that recommendation will go up to the full task force. If we can, focus the lens here and get those recommendations in our agenda, it'll help, prioritize the time of the full task force. So don't worry, we're not making any, citywide reaching laws at this point. Having said that, I think there's a balancing here between what the Commission was trying to do and the requirements of the Sunshine Ordinance. However, this is also a slippery slope. There's been many times, and you can ask our own clerk, where we've had materials that didn't make it under the 72-hour threshold, and therefore we could not agendize, had to be postponed to future agendas, future months. And many departments comply and do that. I think if we don't find a violation here, this kind of opens that door for people to slip in last-minute amendments and stuff and whatnot. This item probably was the item of the night, that night on the agenda. I think it falls squarely under 67.9A to the extent possible, such documents. So, I mean, you could backtrack and say, well, the commissioner should have told these other parties to get the documents to them so they could notice it and have this meeting, per Sunshine requirements. And, they would be required to know that at the very least. So I think we need to record that there was maybe, or I would like to suggest to the full task force to find a violation, if nothing else, to record it, so that, this doesn't become a pattern, in the future. I think on the other hand, I think the Police Commission is one of the better ones. They've come before us a few times, and I think they've been pretty knowledgeable on Sunshine. I think in this case, there's a lot of things going on, and I can certainly see why they ended up where they did. But I think it would be remiss of us not to suggest the full task force find a violation.
Member Moss, anything?
I have a lot of thoughts, but I don't know I have any that are articulable at the moment.
Yeah. I mean, I'm tending to agree with Member Highland. My concern here, and again, we've had this before us, is what is substantive and what affects and how it affects the public. And in this case, even to me, average intelligence, even if I had all 2A, and 3 to compare, in order to tell the differences, I'd have to go through each document and compare strikeouts. And a 30-minute recess, to me, just doesn't, for me, would not have been sufficient to do that, especially on such a serious issue. So, do we have a motion?
Sorry.
No, go ahead, Member Moss.
I mean, I feel more comfortable on the issue that there was a substantial change between these two documents than I am the 72-hour issue at this point. Although I do think that you make a compelling argument, and I do feel like this would benefit from the full consideration of the task force. I don't know that I may reach a different conclusion then than I do today.
Yeah, I mean, through the chair, I agree. Whether, ultimately it's the city departments and the department heads that need to know the Sunshine Ordinance and need to be able to direct groups or bodies that are outside of our purview. And by the way, get your documents together because we need to notice this adequately. This is a major deal. So we need it by, Monday. We need it by, whatever it was to have this. Or we're going to have to push back a whole week to the 29th if we can't get it by this date. That might have been a reasonable recourse. Get the document, post it on the website, distribute copies at the meeting in a perfect world. I mean, I realized there was a lot going on at the time around this issue, and but that's not for us to rule on. Ours is just the letter of the ordinance, and based on that, certainly one part, but maybe not the other. So I think what we can do is perhaps craft a concise recommendation so that the full task force can cut to the meat, and we can get this moving forward efficiently.
You do have the other option. Usually we send it with a recommendation for adoption. We could send it to the full task force with a recommendation and a request to have a de novo hearing.
Yeah, I think we've spent quite a lot of time on this. I'd like to at least send it with some recommendation, would be my instinct. And then, Member Moss can certainly step up and say, I'm comfortable with Part A, but not Part B for these reasons, and kind of get the task force up to speed. And they can always reject our recommendation, right, and go into it as a de novo at that time. Is that correct?
We would have to reschedule for a future date.
We'd have to reschedule it. Yes. That's the point, too.
So, I mean, just sort of jumping back to another thought on this. So, if this had come to the police commission through another means, this entire draft, if somebody it had not been handed to them 45 minutes or an hour in advance, if somebody had come up through public comment and said, I've written this great draft here, and slapped it on the table, and then the commission had discussed that great public comment that they'd received and then crafted their policy that they were going to approve based on something that had come through public comment, would we be sitting here having the same discussion? Would that have been a violation?
I believe so, because again, that would need to have been distributed so that everyone could have an idea of what went into that version of the document.
But there's a certain amount of leeway, though, for making an amendment to a policy during a commission hearing, or does every time they need to make an amendment, does it need to come up?
But think of it this way: what if that version 3 was adopted, signed, sealed, delivered? It hasn't. It's moved on, and there's been ramifications and changes. But the point is, it could have, or for all intents and purposes, was at that point. So I think just the volume of changes alone, the fact that they did have a copy, they could have put on the internet, even if it was a few hours before the meeting. They could have done that. They didn't do that. These are all things that could lead to violation.
Excuse, what time does the normal police commission meeting start?
The commission meeting starts at 5:30. We are at the Public Safety Building, which is on 3rd Street, and the traffic is horrendous. We have to leave there. We cannot leave there later than 4 o'clock to get here.
Understood.
Right,
And just to clarify the record, it was not on the item for adoption. It was moving forward
Correct.
so it could have happened is not true. It could not have happened. It was not on the agenda for adoption.
Right. Thank you.
Thank you.
I understand getting to the meeting, but this is such a digital age that somebody who actually put together the final version 3 could have thrown it up on the website. So, okay. No, thank you.
The person who compiles it was not a member of the
That's
department.
fine. Okay.
They couldn't have access.
You have a motion, Member Highland.
Let's see. Okay, so propose a motion to find a violation of 67.9A. Member Moss?
Should I?
I'm still-
Procedure-wise, are you still talking, or?
No, I'm still, but I'm open to amendments. I'm open to,
So when you're talking about 67.9A, I mean, based on what the chair just said, to the extent possible, such documents should also be mailed available through the policy body's internet website.
That's the
I do
piece.
feel like the email of when they were ready to circulate, it was 3 o'clock. The meeting started at 5:30. Even if they have to leave no later than 4, that's still an hour that something could have been done, I feel like.
Yeah, I mean, there was, at least pop it on there and throw it out there. I don't think they were trying to rush anything through, but that would have been a wise precaution. If nothing else, at the end of this exercise, this department and other departments may learn to get them on the website and then get to the meeting. That would be a great improvement.
Okay. So is that's your extent of your motion there?
But I'm open to amendments. That's the piece I'm seeing. I'm reading through the rest of the 67.7. And 67.7 was the agenda posted 72 hours before the meeting? Yes. And did it contain an adequate description of the agenda item? Yes, I think it did. This is an ongoing item. It's clear what that is. So I think it's only...
Yeah. I'm comfortable with 67.9A.
Yeah, that's the piece that I would single out.
Yeah.
All right, then I'll second that motion.
Okay. We have a
Just
motion.
Give me a moment. I would like to restate that, just to be sure that we are clear on the section. Is the motion to find a violation of 67.9A for failure to post the document online when it became available?
At 3:48 p.m.
3:48.
Sorry, where's the 3:48 coming
That's
from?
in one of the emails, but I mean, just so we can...
So I have one at 3 o'clock that says, looks great to me, this needs to get to the commission, and we need to get copies out.
Okay. Well,
So that seems 3 o'clock to me as a better
Okay, I didn't
number
see
than
that.
3:48.
All right.
Sorry, I just highlighted that
I don't
note.
know, do we need the time?
we probably don't need that detail,
You don't need the time, but I
but it'd be
would like-
nice to have that detail so that a month from now, when the full commission,
Right.
we're going to remember, oh yeah, that was the,
That's page 173 in the packet, if that helps.
yeah, why don't you reference that, Victor? Yeah.
Sorry, can I just mention?
No, you please. No.
There was one
Ma'am,
at 48, you were correct. There was one at, was the last one was at.
It really doesn't matter. I think there was time for it to be posted.
Okay.
So the motion was to find violation 67.9A for failing to post the agenda online when it became available.
Right.
Okay. Any public comment on the motion? He spoke. You spoke. You were speaking.
Your party.
Seeing no public comment, let's have a vote.
On that motion, Member Highland.
Aye.
Highland, aye. Member Moss.
Aye.
Moss, aye. Chair Kanata.
Aye.
Kanata, aye. This motion, this recommendation will be referred to the Full Sunshine Ordinance Task Force meeting. The complainant and respondent are invited to attend, but are not required
Do so.
Thank
to
you.
do so. You will
Okay.
receive a copy of this recommendation once it is signed by the chair.
Okay, so now we're back to the item that we tabled.
Thank you very much for your time.
Thank you.
Yes, we will, is there a motion to recall item number 5?
So moved?
Second,
Yes.
and
I could call Ms. Horn to return, however,
she is here, and the,
She was hiding behind the guys. She scared you.
the complainant is not present. I have not received any communication. My recommendation is to table the matter, and I will also inform the complainant and give them the option of reopening the file if upon request.
okay, that's fine. Do we need any motions for that, or
Yes, please.
Just for your information, I would just indicate.
can you
Could you
use the
speak?
microphone, please?
The city attorney indicated to me, and I think as part of my response to a request for mediation, I forwarded the city attorney's number, and they indicated to me that Ms. Butler had been in contact with them, and they were going to provide a redacted copy of the list, which they evidently are in possession of. So, and that may have affected her not coming today.
She may have received the documents from the city attorney instead of the sheriff's office.
It sounded to me like the city attorney hadn't sent it out yet, but they would this week.
Okay.
Well, Through the chair, well, hopefully that'll conclude it, and thank you for waiting around an hour and 20 minutes. Perhaps we should have let you talk earlier with that information. Sorry about that.
That's okay. Thank you.
Okay, so
Is there a motion to table the matter?
Motion to table the matter.
Victor, just explain to us tabling the matter. What does
It is
that
killed.
exactly mean? It's
Technically, it's killed.
See, it sounds like it's not.
Doesn't sound like it. Then I
Right.
retract my motion to table it, and I will let somebody else.
We can discuss this. So, and this is one of the things that the rules subcommittee is going to look at as far as the mechanics of no-shows, basically, and how to treat it. Victor, thank you. What is our working policy right now? Is it?
If the complainant fails to attend the meeting and does not so inform us prior to that meeting, it shall be the practice of the task force to table the matter. We will so inform the complainant, and they shall have the option to reopen it if they so request.
And that item would then go to the back of the queue to be heard at a future
Yes.
time? Okay. I think that's
and it
reasonable.
sounds reasonable to me since it's the complainant that is the no-show.
Right? And it sounds like this is going to
And they still
resolve
have the
anyway.
option to reopen if they so inform.
Yeah,
Right.
okay, all right. Motion to table.
Second.
Public
Can we
comment?
pass that
Public
without,
comment on the motion. Seeing no public here.
can we pass that without objection?
Yes, we may. Okay.
Next on the agenda, item number 7, file number 16080, hearing, review of potential impact of Assembly Bill 2853, public agencies' referrals of persons to public records maintained on an internet site, pending approval by the governor on the city and county of San Francisco. I have been so informed by Member Moss that the governor has actually signed this matter at this time.
Okay.
Okay, can we still discuss it anyways?
Sure, go ahead.
So, the reason I brought this up is this is a new section of the California Public Records Act. I'm going to go ahead and read it out just so we have it. In addition to maintaining public records for public inspection during the office hours of the public agency, a public agency may comply with Subdivision A by posting any public record on its internet website, and in response to a request for a public record posted on the internet website, directing a member of the public to the location on the internet website where the public record is posted. However, if after the public agency directs a member of the public to the internet website, the member of the public requesting the public record requests a copy of the public record due to an inability to access or reproduce the public record from the internet website, the public agency shall promptly provide a copy of the public record pursuant to Subdivision B. So if I can just break that down and explain it in a little more simple. So this doesn't change how a person can come in and inspect a public record. That stays the same. However, if I file a public records request with any agency, I mean, this is just ignoring the Sunshine Ordinance for now. This is just for any government agency, local government agency in California, or state agency in California for that matter. If I file a request with the agency, rather than mailing me the public records or sending me via email, they can upload it to their website and then they can send me a link to that, and that would satisfy the request. However, if for whatever reason that doesn't work for me. So, for example, say I am someone who is poor and I do not have access to a computer, and I do not have access to a computer, and I do not have access to computer paper, or any combination of, then it's just I'm a disabled person, and looking at a PDF just is not the optimal way for me to look at a record. Then I have to go and file a email or letter back to the city or the county or the state saying, hey, I have an inability to access this link. Then they get to send you the public records the traditional way. My concern with this and how this will end up playing out is that it will result in a longer response time for people who do not have access to a computer, do not have that kind of privilege, or people who have a disability that prevents them that. And I'm not sure how this interacts with the Sunshine Ordinance, whether the Sunshine Ordinance is going to supersede that in a certain way, but if there's something that we can look at to ensure that the Public Records Act doesn't disadvantage the poor or the disabled, I think that would be optimal.
Does this new amendment stipulate that if the person asking tells them, I don't want it on through your link, I want you to send it to me?
So as written, they can ignore that until after they've sent you the link. So you can ask for that up front, but the law does not say that they have to honor that. The way it's written is specifically if after the public agency directs a member to the internet website. So they can still, if you say, send your request saying, listen, I really need a paper copy of this, like that's the only way I can manage it. I'll pay you the 50 cents for 2 pages of it, but please send it to me. They can ignore that, send you the link anyways, and then you have to send that letter saying, please give me paper. And then that's another response time that's going to, it's longer.
I believe that the Sunshine Ordinance does have a section that states that the department shall provide the requested records in any form requested that is easily produced. I'm trying to find that section, but I think the Sunshine Ordinance, if they do request it in a certain format, the departments should comply with the request for the format.
Okay, and so the Sunshine Ordinance in this regard supersedes any amendment to the Public Records Act. If that's the case, then that answers it for me. I just wonder if...
I'm trying to find the section for you.
I remember reading that, but I don't remember the section.
Is there the means for us to send out a message to agencies, or that is the case, that they can't use this to delay public records requests?
Through the chair. Yeah, in many cases, when there's legislation and things on the landscape changing, we've taken a position and we've sent a letter, domestic, or within California and nationally, stating our position on it. So that's certainly something we can do, and we could certainly recommend that to the full task force, and it could be an item for discussion. And I imagine you'll be drafted to draft the letter, or a volunteer for that if you'd like to, and then we would approve it as a committee and then send out that letter. Yeah,
that sounds fine to me.
Okay.
But I think that we have some research that's going on real quick.
Okay.
I guess, one of the issues here is we just don't want to have confusion going across agencies here based on a new law that does not mirror the Sunshine Ordinance. And that, in theory, I'm not against the idea of a agency having a portal where it uploads data and for the sake of convenience makes it available to people. But I do feel like if you request on the front end, you should be able to get it just like a normal public records request rather than this whole other step.
Might even be worth a letter from us to them. Is this in law yet, or is this?
It's in that stage between where the governor has approved it, but it probably hasn't been chaptered by the Secretary of State. I don't think that they're. I'm not, that intimately familiar with the parliamentary rules between the governor's office and Secretary of State, but it doesn't seem an opportunity for him to revoke his signature at this point.
Yeah. Okay.
I believe it's Section L of Section 67.21L. Inspection and copying of documents of documentary public information stored in electronic format shall be made available to persons requesting the information in any form requested, which is available to or easily generated by the department, its office, or employees, including disc, tape, printouts, or monitors at a charge no greater than the cost of the media.
And keep in mind that was written 20 years ago. Disc,
right. Tape,
printout, or monitor. That certainly would need to be updated when that time comes.
Do we have a guidance document for requesters that might benefit from being adjusted to?
We're actually working on that, and I think that's going to come out of rules as well.
EOTC,
Is it EOTC?
Sounds
yeah.
right.
Yeah, EOTC is working on
maybe
that.
transferred to rules.
Yeah. But that's a work in progress, kind of like cliff notes on how to do a good sunshine request. Yeah.
So if we're going to, the action here for us would be to send a recommendation, is that correct, or a referral, or what is the thing to get this to the full task force?
Make a motion to request that the task force send an advice letter to all city departments regarding this matter. And I assume the advice would be provided by what's to be included in that advice letter. We should provide a suggestion.
Okay. And then
Or
if we wanted also, in addition to that, get something to the EOTC committee that they should consider this in whatever, and if they're moving it to rules, then push it on to rules as well.
That could be part 2, yeah.
Okay. So I'm just trying to think of how to phrase this before I make a motion to phrase it, but if anybody has any ideas, it would be
You can just say, what's the number of the legislation, the piece?
AB 2853 is what it's been under. I would probably stick with that because,
Yeah.
I mean, I can give you the section under the California Public Records Act, but it's...
No, it could just be the format of an advisory letter from the Sunshine Task Force to all city departments regarding AB 285, our interpretation, and a reminder of 6721 L. That paragraph supersedes or trumps this particular. Just to remind, just something like to that effect.
That sounds really good to me.
And we have had a previous case where we have informally informed the planning department. They were responding to requests via email, even though it was specifically requested that they respond via U.S. mail. We've advised them that they need to respond in the requested method.
Okay. So just to make sure I'm phrasing this right, because it's a whole lot to hold in my head. So we are asking the task force to draft a letter, to send an advisory letter to all city departments and committees, making them aware of AB 2853, and that reminding them, well, it's sort of, I've lost track at this point. You had it said it so well.
6721L of the Sunshine
and how
Ordinance supersedes
AB 2853. Does that sound about right?
Yeah, and we may discuss, whether it does or what exact wording. But basically, it's just basically a notice about AB 285 and the Sunshine Ordinance's position on that.
Okay.
And that the 10-day, the standard deadlines listed in the Sunshine Ordinance stands and cannot be delayed, or something to that effect.
Mm-hmm.
Sure.
That's very useful.
So do I have to try to state that all again?
I think he has it on. You have it on tape. Do you want me to try one more time?
No need.
Yeah, he has it.
Okay, so...
And then part 2.
I will provide you an initial draft, and I would hope you'll be able to edit it so that the task force has something to work with in approving a draft letter, so they're not doing it like we're doing it now.
Sure. Yeah. And then the second part is just to include that piece in the working document for the EOTC.
Yes, that's separate. I could just write a hearing file and send it over to them.
Yeah.
Okay, so do I need to make a motion? Yes.
Yes, a motion to draft a letter for the full task force approval regarding the assembly bill and the vice previously discussed. I will draft that.
Okay.
Provide an initial draft for you to review.
Okay, so I make the motion to... Gosh, I'm losing us here. Sent to have
Just say this, the motion as amended.
The motion as amended.
Second.
All right, thank you.
Okay.
Wasn't that easy?
It's a lot to
Public
keep in your head.
comment? Seeing none, let's vote.
Can we pass that without objection?
Yes, we may.
So moved.
Without objection. All right.
Sorry about that, guys. My brain is just not holding stuff at
The motion
5:30.
language can be complicated at times. Next on the agenda is item number 8, file number 16081, hearing review of Senate Bill 272, Amendment to California Public Records Act and development of plan for implementation.
Should I take this one away as well? Okay.
Feel free, yes.
So SB 272, I can tell you quite a lot about. So this passed last year. The requirements in it took effect July 1st. This is under the California Public Records Act now. every local agency, this would include the city and county of San Francisco, must post what is called an inventory of enterprise systems. And enterprise systems here has a fairly complicated definition, but for the sake of making it easy to understand, we're talking about databases. We're talking about data systems that either serve as a primary record between agencies or contain information on members of the public. And each agency is supposed to create a list of all of these and post it to their website. City and County of San Francisco have done so, and it generally looks pretty good. However, the concern I wanted to raise, and just sort of in general, I think I raised this issue for us to talk about so that 2 months from now we can have people who are knowledgeable working on this on the city can come in, and it's easier to talk about this rather than having a seriata meeting about it, because you can't do that. So I would like to have, I guess, the custodian of records or the administrator of records, as well as someone from the Open Data Hub, come and talk about how they're compiling this data and what the quality control mechanisms are for this data. The big concern for me that I've seen in just sort of looking through it myself is that for each enterprise system, there are supposed to be 7 items that they list. And the items are the current system's vendor, the current system product, a general description of categories and types of data, the department that serves as the system's primary custodian, how frequently the system is collected, and how frequently system data is updated. Items 3 and 4 I want to read again. Number 3 is a brief statement of the system's purpose, and number 4 is a general description of the categories or types of data. And the problem is that with the enterprise system inventory that San Francisco has, it has taken items 3 and 4 and combined them into a single category, resulting in very little information about either item in there. So what you would hope is that for a brief statement of the system's purpose, you would have a brief statement of what the system is for. And then under a general description of categories or types of data, you would say we are collecting biographical data about people, or we are, giving some idea about the different types of data. But in practice, how this is just like 3 words to describe the 2 most important categories of data in the system. And that's something I would like to ask whoever's managing this enterprise system inventory about, and why that decision was made.
Can I ask a quick question? Is this the same as the index of record, or is this a separate?
It's a separate thing. I think I'd sent along a link, but it's on the city's website. I mean, I don't know if I can bring it up on the computer to show you guys. What's that?
Oh. Yeah, I was just thinking it was the index of records, but it sounds completely different.
It's called according to the SF Open Data, it is the Inventory of Citywide Enterprise Systems of Record, and then it says in compliance with CA Government Code 6270.5, passed via SB 272, the city must publish a catalog of enterprise systems that collect. And there's a whole lot of stuff. But if you go to, if people have computers, I can tell you the link that they've created for it, if that's helpful in understanding what I'm talking about. Actually, that's not a useful link.
If you can send it to me, I will send it to all the members and put it into the minutes.
Okay.
So this is just a list of the data stores and theoretically what they're about, what type of data, but it's not in any way, shape, or form meant to have the public to have access.
No, there are certain. Once you have this list, I think the theory is that some of these things on this list, people would be able to file a follow-up PRA to get the data set. That's not going to apply to all of them, but some of them it will apply to. But also part of the purpose is that you get a good idea of what kind of systems that, say, law enforcement might be using. And maybe you wouldn't necessarily know what's in the data system, but there's a certain level of transparency to know whether they're using, like, military-grade predictive policing software. They're not going to release that data set, but it's good to know that they have it. To just sort of give you an example of I'm looking at one that's it's some system for adult probation, and the 2 items are supposed to be brief statement of purpose and general description of data. That line is risk and need assessment software. It doesn't tell you what kind of data it's collecting, and it doesn't tell you what the purpose is, unless you can somehow, I don't know what risk and need assessment is, a little bit more description would be. So, I mean, I'm not sure what the worksheet is or the instructions that have gone out to how to comply with SB 272. I would hope that it would be a little bit more robust, and I have a feeling that we might start getting complaints about this before too long, that somebody might come in here and say, the California Public Records Act requires, these two bits of information and neither of them on here, and then Sunshine Task Force do something about it. And I'm not sure what we could do or what we would do, but that's something we probably need to think about.
All right.
So,
now to package that nicely in a recommendation.
So my recommendation is for us at the subsequent meeting of this committee that we ask for the responsible officials within the city government who run SF Open Data, and also, is it the Administrator of Records? Is that the official title of the records person? Chairman Wolf had suggested.
I believe that would be the city administrator is responsible for. They're responsible for the index of records, but that sounds very similar. We can ask.
Yeah, I think what I would want to know is who's in charge of this, and I would imagine there's someone at SF Open Data who is partially in charge of this, but there may be somebody else. Is it possible for us to just investigate and figure out who to invite?
I will review the website and see if I can figure it out.
Okay. I guess
And
that's.
may I suggest that, or may I ask, would you like the hearing to be at the committee level?
I believe that Chairman Wolf was hoping we would deal with this at the committee level first. I don't have anything to necessarily report. I mean, main thing is we need to have somebody come explain it to us a little bit.
So I will work with Member Moss to develop a hearing title and find the correct people to contact to invite to the meeting. I don't believe we need a motion at this time, or you can make a motion to request a hearing be scheduled before the full task force regarding this matter.
No, I don't think I need that if I want it to be in here. So.
Yeah, I would say let's have the person come here and address us, and then
We can present
We can
those
present
findings.
Yeah. I just wanted to make sure that, because when this came up at the task force, this was the next hearing of this, and I didn't want to wait until 2 months to
And
try
we
to
can
discuss
invite
it.
Chair Wolf to attend that meeting, should he.
Okay. I guess the motion would be to schedule a hearing before the Compliance and Amendments Committee regarding this matter, and I will find the people responsible for the database and invite them to this meeting.
Okay.
No motion
We need
required.
a second?
Do I need to make a
I
motion on
need
that?
somebody to make. I can't make the motion.
Oh, so sorry. Move as amended.
Second.
Very good.
I'm learning.
They're learning quickly. Proud of you guys.
Can we take that? There being no members of the public in the
No.
room, can we take that without objection?
Yes.
That motion passes without objection. Next on the agenda is item number 9, announcements, comments, questions, and future agendas items pending calendar by members of the committee. I do note that we still have the same one listed, the pending item 14101. I did contact the building inspection. That program involved still has not been finalized, so there's no documents to produce to the complainant. We probably shouldn't have continued this, waiting for the program to be finalized. I do suggest that we schedule this for a hearing in the near future to ask each party to give an update and to close the file. And if they have additional complaints in the future, they can refile a complaint.
Okay. And what, just quickly, what,
It was a program
issue
to
was this?
track trees. It was some kind of program for DBI to track the maintenance of trees and so forth. And they were developing a program for that. The complainant requested copies of the screenshots of the program, but since the program has not yet been finalized or created, there was nothing to provide. However, the committee at that time was interested in the program, so they continued to the calls to receive updates, but since there's nothing to provide, we probably should close out the complaint.
and you said DBI, not DPW?
Sorry, I'm not sure what I wrote here. Building inspection. It is building inspection.
Okay. That just seems strange to me that they would be in charge of trees.
It might be associated with homeowners.
It is.
certain.
So it's not city-owned trees.
Exactly. It's well, no, it is city-owned trees. I think it's, for instance, when I recently redid my place a few years ago, I received a picture that was inserted into my package online saying, "There's no tree in front of your house. You're deficient in terms of getting a work permit approved." That's all part of it. Surprising, and that falls under DBI, even though DPW or urban forest would be the one that would come and plant it. You know, you have to make that happen. So, interestingly,
So,
I think that's what this is probably
okay.
stemming
So are you saying that if you are, is there a, I mean, I'm all for trees. We had
I'm unaware.
We
This
had
is-
Friends of
this
the
is-
Urban Forest. Finally, we could get one in front of our place. But are you saying that they're going to require you to have a tree?
Just from my recollection, even though it's that piece of the sidewalk is city property, you are responsible for the maintenance and planting of that tree, unless it falls within, like in my case, Guerrero Street beautification project. So I was off the hook. But yeah, that is.
I think that's good. We need more trees.
Trees are good.
And I will try to work with the parties and get it before the task force so that we can
Okay.
close that out. And just, that completes the agenda, as far as I know.
Sorry, can I just ask further questions under this?
Yeah, go ahead.
I just for history, maybe Member Highland can help me out here. The amendments portion of Compliance and Amendments Committee that refers to amendments to the Sunshine Ordinance, is that correct?
No. You're asking about the function of the subcommittee?
Yeah,
in
yeah.
general? I think it's to make sure that that orders of determination are being carried out. That's the primary purpose. I think any changes to the ordinance would probably go to rules first and then come to the full task force, if I'm not mistaken.
However, I'm not sure if you're aware, but amendments to the Sunshine Ordinance
Be a voter.
most likely need voters' approval, unless it's to improve the ordinance. However, the city attorney rarely states any amendment qualifies as an improvement to the ordinance.
Yeah, I think procedural or technical changes, non-substantive changes we can handle, but anything major would have to go back for a full.
I have the bylaws here, and it
Yeah.
basically says.
There you go.
The Compliance and Amendments Committee may monitor compliance with the orders of determination adopted by the task force, shall recommend to the task force amendments to the Sunshine Ordinance regarding enforcement of the orders of determination, and shall consider and recommend any other addition, amendments, and changes to the Sunshine Ordinance as provided by members of the task force and from the general public.
So wait, I think the version you read is a different version than I read. Which version of the bylaws are you looking at?
Which version? It's good. This was added 8/27/02, the one I'm reading.
That
And
sounds
this-
like
I'm looking at
it's
4/1/2015, where it says the Compliance and Amendments Committee may monitor compliance with the orders of determination adopted by the task force. We've done that.
Right.
Monitor changes in state law and court decisions affecting access to public meetings and records. We've done that. And make recommendations to the task force regarding amendments to the Sunshine Ordinance. And I just want to make sure I understood what that is. That we make recommendations to the task force after the voters have approved amendments to the Sunshine Ordinance, or we?
There's no specific interpretation.
Okay.
It sounds to me as if you can make recommendations for changing the Sunshine Ordinance to the full task force, and the full task force would usually have to draft either a charter amendment or something to go to the voters or something to go to the Board of Supervisors for approval and so forth. But
Okay.
it sounds like you can make recommendations, but after that recommendation, I'm not sure how the full task force would proceed with that.
That's fine. I just wanted to make sure I understood. I have no amendments to the ordinance to suggest today.
Okay, so adjournment. Meeting adjourned.
Very good. Very good.